case briefs, and so much more. LSData's got what you're looking for.
In a 2018 case heard by the Court of Appeal, 5th District, California, a couple sued a hotel and a maintenance worker's employer for negligence. The situation arose when a woman checked into a hotel, but later failed to answer her husband's calls. The concerned husband called the hotel's front desk, asking for someone to check on her. A maintenance worker, employed by a staffing agency, went to the room and reported that no one was there. Hours later, the husband went to the hotel room and found his wife lying on the floor with a brain aneurysm. The court focused on the negligent undertaking theory of liability, which states that if someone decides to help someone else, they must do so carefully, or else they may be held liable for any harm caused. The court found that the maintenance worker may have assumed a duty to check on the wife's well-being beyond just opening the door and peering inside, which would make the employer liable. However, there were disputed material facts about the scope of the worker's duty, and the court reversed the trial court's grant of summary judgment. The court directed the trial court to deny the defendant's motion and determined that the issue of breach was a question of fact for the trier of fact to resolve.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.